Good evening. I think the microphone's working. I think, as we all know, the information revolution has wrought any number of changes, economic, social, political, diplomatic, and it can be said that the information revolution is, in its transformative effects, somewhat analogous to the Industrial Revolution. And with it have come any number of difficult issues, and dealing with those politically as well as in the business sector and socially, as we all know, given social media, presents any number of difficult challenges. We're lucky this evening to have someone who has spent a great deal of time on some of these issues, particularly privacy and social and civil liberties. Steve Glassman, of the Executive Director of the Connecticut chapter of the American Civil Liberties Union. Now, Steve let me give you a bit of Steve's background. He served as a board member of the Maryland ACLU for 8 years, of the Pittsburgh chapter of the Pennsylvania affiliate for 3 years. From 2002 to 2011, he served as the chairman of the Pennsylvania Human Relations Commission, appointed by Governor Rendell, for which he was twice confirmed by the state senate. Steve's got an unusual background for someone dealing with a range of civil liberties issues, I should note. Before assuming his current position, he was president of the Community Design Center in Pittsburgh, Pennsylvania. Earlier in his career, he practiced architecture for about 25 years. He also served as vice chairman of the Baltimore Civic Design Commission, co-chaired the first national conference on diversity in the design professions, and served for 5 years as the vice chairman of the diversity committee of the American Institute of Architects, a national board of directors. Steve's academic background is also in line with that. He earned a bachelor's degree in art history from Brown, a master's degree in architecture from Yale, and a postgraduate degree from Harvard University's Kennedy School of Government. So I won't take up more of your time. You shouldn't listen to me, but listen to Steve Glassman. Thank you.
Thank you. It's really a pleasure to be with all of you here in Stonington, one of the most charming places I've had a chance to visit in the last 15 months since I assumed this position at the ACLU in Connecticut. We have a number of donors who actually are here in Stonington, some of whom have taken me sailing, so this community is really one of my favorite in the state. So it's a pleasure to be back here today. I thought I would talk about some of the major issues we are confronting here in Connecticut as well as nationally, and then get into that realm of privacy that seemed to be the issue that people were more interested in perhaps hearing about today, but I'm happy to answer questions, obviously, about anything that's of interest to you with regard to the entire spectrum of civil liberties or civil rights. First, I would like to just share with you that the ACLU, the American Civil Liberties Union, is now 96 years old. We'll be celebrating our centenary in 2020. And when you think about the time in which the ACLU was founded in 1920, the very first case, which was the issue that spurred the creation of the ACLU by Roger Baldwin, was the Scopes trial and the issue of evolution, Darwinism. That was what started the ACLU, and it has been at the forefront of every major social justice movement and intellectual movement that's confronted the governmental intrusion into private life ever since then. So many of the cases that you're very familiar with, or issues that have been transformative in the history of this country, have really come about because of suits that have been filed by the ACLU to make a public statement about what the government is and is not allowed to do with regard to interfering with all of those liberties that are guaranteed in the Bill of Rights and the Constitution. Some of those include your Miranda rights. It was a very important ACLU case. The case which confronted all of the Japanese who were interned during World War II, that was an ACLU case that got that overturned, that executive order overturned, and that law that was passed by Congress in order to close down those, what were essentially concentration camps here in the United States. One of the cases that is most evident to all of you, I think, because you're Connecticut residents, was 50 years old last year, and that is the case which obviously was so critical with regard to women's rights and with regard to the issue of privacy. The very first time that privacy was ever looked at as an opportunity to expand our understanding of individual freedoms and rights and collective freedoms and rights in the Constitution, the Griswold versus Connecticut case 50 years ago. Because we're talking about privacy today, that's really when privacy began as a concept, and then it has been cited and used multiple times in Supreme Court decisions ever since then. Some of the more important recent fights that the ACLU has been at the center of, the most recent of which was the Obergefell versus Hodges case 2 years ago in granting same-sex marriage. That was an ACLU case, and in fact 4 of the cases that were consolidated that went to the Supreme Court to ensure marriage equality were ACLU cases. So we're not only reactive and on the defense against what we find acts of Congress and executive orders to produce, but we're also proactive in identifying areas of cultural shift in this country and then looking at opportunities and ways in which we can ensure that those rights, whether the due process, equal protection rights, or rights that are guaranteed in the Bill of Rights in the first 10 amendments, are able to really enhance protections and expand individual liberties and freedoms for everyone in this country. Here in Connecticut, it's been a really interesting time in just the 15 months that I've been here, because many issues that have been popping up all across the country have actually been able to be addressed here in Connecticut, because this state is generally much more open-minded and blue in the political spectrum. We've been able to really use Connecticut as a laboratory and a model for legislation that is being passed here in Connecticut, that was passed in the last session, which was my first session here, and that we're currently advocating for in this legislative session. But as an example, the second chance legislation that was passed in the last session, which is designed to reduce mass incarceration and to defelonize nonviolent drug crimes and mental illness related crimes, is reducing the prison population in this state by another 7%, or 1,100 prisoners. Connecticut is actually the third best state in the country with regard to the percentage of reduction of prisoners in its system in the last 5 years. It's gone from a little over 20,000 to just under 16,000, and this, over the next year, will reduce the prison population down to just over 15,000. It's still a lot more people than ought to be in prison, because obviously the system has exploded all over this country in the last 25 years since 3 strikes and you're out went into effect. Just in Connecticut, as an example, from the early 1980s until now, the prison population went from just over 2,000 to over 20,000 in just that short period of time. And obviously, people haven't changed significantly. It's the way we have dealt with problems that we see and how they act out in society. And instead of using a medical model or a social construct model, we've used a punishment model. And that obviously hasn't been effective, and it's caused great consternation for those people who have been incarcerated for long periods of time, as well as their families. But as an example, one of the issues in which we're involved currently in the legislature is advocating for the governor's proposal to raise the age of juvenile justice. We'll be the first state in the country to actually do this from 17 to 20, so that in responding to a lot of scientific work that's been done in the last 20 years regarding brain chemistry and formation and the maturity of individuals as they grow, brains are not fully formed, particularly with regard to judgment and behavior, until your mid-20s. And so looking at ways in which we could help young people who get into trouble be able to understand what their opportunities are, how to use corrective action in a way that still doesn't put a scarlet letter on them for the rest of their life so that they can never get a job, never be able to rent an apartment, never be able to move forward in their lives. You literally can have two seniors in high school whose birthdays are a couple of months apart, and one will end up for the same, minimal nonviolent crime, end up in the juvenile justice system, which is rehabilitative in nature, and the other will end up in the prison system for adults, in which they could be incarcerated for years and their entire life could be destroyed. I think you're all probably aware of how challenging it is to be able to obtain employment after you have a prison record. So one of the other bills that we're advocating for strongly in this session is a ban the box bill, which would mean that employers, when they're interviewing, would have to go through the interviewing process and then make a decision about whether or not they wanted to advance a person who's interviewed to the next stage of employment before being able to ask about their criminal background or history. In other words, you'd still be able to not hire the person if you felt they were not the right fit or their criminal background was too difficult for you to get beyond. But what it does is allows people to get into the system of being able to present themselves and their credentials and their experience to an employer so that they're not automatically tainted and eliminated before they've ever applied, which is what checking that box often does. In the last legislative session, one of the most important pieces that we passed was the first and only of its kind in the nation, which was our excessive use of force police accountability bill. So after Ferguson and Staten Island and Baltimore and Charleston and any number of other places where we've watched unfortunate breakdowns in the relationships between community partners, individuals, police, we were able to respond in Connecticut by passing a really comprehensive and extraordinarily long-range thinking bill, which would, first of all, provide funding for body cameras for every one of the 102 police departments in the state and the state police. It mandates that if there's a violent crime that leads to a death on the part of police, that there be a special prosecutor appointed from a different district than the district in which the crime occurred in order to avoid collusion politically among police chiefs and district attorneys, prosecutors, and elected officials. It mandates minority and women hiring and policing so that we get a better representative police force in as many places as possible in the 169 municipalities in Connecticut. It also mandates that every person has a constitutional right to film or record any interaction between police and an individual who's a suspect, and that not only will the police department be liable, but the individual police person who takes that phone or stops a person from recording or filming is also going to be liable. And it also mandates that if a person who's a police officer is convicted of any of these crimes, that they will not be allowed to be hired anywhere else, not only in Connecticut as a police person, but that their record will follow them all across the country. So the few bad apples that exist in police departments are not going to find themselves able to do the same kind of bad behavior in other jurisdictions, whether it's in Connecticut or around the country. So it's quite a comprehensive bill, and I think that only in Connecticut could you really see an opportunity to pass some of these foresightful and prescient pieces of legislation. So we continue to work on criminal justice reform, but I'd like to try to talk to you a little bit about privacy issues, because I know that was of heightened interest here in Stonington, and there are some really important things that you've all been reading about in the news with regard to, obviously, the Apple phone controversy in San Bernardino, California. But you also, I think before I get into that one, which you've all probably read about, I want to tell you about something that's happening right here in Connecticut. It's happening all across the country, but we're addressing it. And we are very likely to have the very first bill in the country in this legislative session pass. There's widespread bipartisan support for it, a cell phone tracking bill. Do any of you know what stingrays are by any chance? Not the fish and not the car, but do you know what a stingray is? So, portable cell phone towers. Only 3 years ago, it cost over $250,000, and only the FBI essentially had these stingrays, and they were also the size of a large suitcase. 3 years later, they're $6,000 and the size of a pocket camera. And that means that any police officer can have one sitting on the front seat of their car, and they will capture every cell phone tower signal within 1,000 yards between whatever 2 or 3 competing cell phone towers there are, and all the metadata and all the individual data on your phone, your smartphone, doesn't matter whether it's an iPhone or an Android phone, encrypted or not, is going to be available so that every email that you send, every contact that you have in your phone, every phone number that you dial or receive a phone call from, not the actual contents of the call itself, but the knowledge of who you called and who you received phone calls from, your passwords, every bit of information that's you store in your phone. I mean, whether foolishly or not, I keep my life in my phone, my calendar, and every one of my 20 passwords for a million things that you have to use in your computer. My phone, like yours, is going to be subject to complete capture by these stingrays. And it's currently happening. There are no laws in the country in any state with regard to any controls over government access into your private technological information on any of your devices. We obviously think this is a serious problem, and I imagine everybody in this room does. So it's striking the balance between allowing the government to do its job properly, allowing law enforcement to be able to, obviously address criminal behavior. We want police to be able to do their work. We simply want them to do it legally and constitutionally. So we want them to have probable cause and to have to get a warrant in order to track a cell phone. It seems fairly simple and not very odd to ask simply that police get a warrant if they have a specific reason why they want to track one individual's phone, rather than capturing all the information of everybody who is driving on the road. They could sit between Hartford and Wethersfield, and every single car that drives by, their cell phone information is going to be captured. Their license plates can be scanned and read. There are no restrictions on this. So all we're asking for is the very basic information that needs to be put into place by police for any suspected criminal activity, and that is you have to have probable cause. You have to have an actual reason why you want to address anybody with regard to your suspicion that they've committed a crime, and then you have to have actual facts and evidence, and you need to be able to get a warrant if you want to track their device. People are not able often to understand the rapidity with which technology is advanced, and what we have not allowed police to do or the government to do that's really well understood with regard to non-technological information, we're very willing to let the government do when it advances to an iPhone or a computer. The government isn't allowed to read your mail. There are laws that don't even allow anybody to actually open up your mailbox because it's federally protected, that your mail is only for you to whom it's addressed, to be able to open. There's really no difference between snail mail that's sitting in your mailbox and email that's sitting on your computer or in your smartphone. The fact is that we get information in many different ways now, and it's intended to be private, and it should be up to the person who is both sending and receiving the information to make a determination as to how private that information is and with whom it's shared. And unfortunately, the laws simply are way behind the technological advancements, and we need to make sure that until laws are passed, we're in there, whether it's through litigation or through public policy statements, but we're advocating very strongly to make sure that people's privacy rights, Fourth Amendment rights, against improper search and seizure are maintained, and that applies to technology as well. So one of the things that we're doing in this current session is we've advanced cell phone tracking bill. We just delivered the testimony on this. It's receiving a public hearing, and it actually is very likely to pass because we had the votes to pass it in the last legislative session. It actually passed the House 147 to 8, in the last session and was ready to go through the Senate by a wide bipartisan margin. And unfortunately, as you probably all remember, the last legislative session ended up in a special session, which was many weeks after the session closed, and it was because they couldn't pass a budget. And we're in a budget crisis in the state currently and will be for a number of years. But the session ended with 220 bills on what's called the consent calendar, where both parties in both the House and the Senate have agreed that these bills are by unanimous consent. They don't have to be brought back to be approved. They just pass a consent calendar. All those bills that have already gone through hearings and through votes in one house are automatically approved by both houses. This was the first year in 38 years that the consent calendar did not get passed. And all 220 of those bills died because they couldn't come to an agreement at the last minute about the budget. The only two bills that were allowed to move forward into the special session, along with the budget, were the excessive use of force bill that I talked about, that was so critical to us, one of our top priorities last year, and the governor's second chance legislation. Both of those were, two of our 5 top priorities. They both went through and they both passed by very wide margins. There's another bill that deals with privacy also that we had a unanimous vote actually in the Senate, 30-0, and we would have had, if it had gotten to the House, very, very widespread consent on this bill, and that is a bill that would deal with drones. You've all watched what's happened with drones over the last year, but when we first introduced this bill, drones were not on almost anybody's radar screen, and very rapidly, because President Obama put into place an executive order that then became a law, that in November there would be regulations on commercial drones. But there are no regulations on government use of drones, with the exception of 5 states that have fairly weak regulations. We put forward a drone bill that would have been the most comprehensive in the nation, and it was on the consent calendar, and it died. But we do have very, very widespread bipartisan consent on this bill, and we just again delivered testimony on it, and we believe that it's going to pass in this session, which will be a very good thing, because there are no controls on how drones could be used. So imagine, for example, that not only the cases you read about in the newspaper with the 18-year-old who's weaponized a drone and put fire starters on drones and to light barbecues and all sorts of really fairly crazy schemes that I think have been widely denounced in the media. But the fact is that the government can use a drone. They can fly that drone onto your property. They can fly right up to your second floor window, be 5 feet away, looking inside at whatever is going on in your children's bedrooms. It's the size of a dragonfly. You can't see it. You can't hear it. It has audio. It has recording. It is taking a record of everything that's going on wherever it wants to go. Drones do not necessarily fall under the regulations that the FAA has with regard to helicopters and airplanes that are at 1,000 feet or higher. So there is this big loophole that is not addressed in almost any place in the country, and we're trying to address that here in Connecticut. So again, if you have a reason to believe that there's a crime being committed or that there's evidence of a crime in place, simply have to go and get a warrant. It only takes an hour for the police to go and get a warrant. But to just be able to spy on anybody that you want to and fly these drones everywhere that now have gotten so miniaturized that they're literally invisible to the naked eye for most people, that seems completely unreasonable to us and an invasion of people's personal privacy. Now, coming to the Apple situation, that is quite complex and nuanced and has a lot of subtleties to it that most people aren't necessarily reading about in the newspaper or seeing on television. We're very strongly supporting the ACLU nationally and here in Connecticut, Apple's, and it's been joined by most of the other technology companies, by Microsoft and Google and others, to not be forced to develop a program to open up information on a phone. But it's much more complicated than that simple statement of what the case is about, because this started in the early 1990s. You all know about encryption. You know there is encryption. There are many different types of encryption. But the reason encryption came about in the technology industry is not because the government requested it. It was because the government was already invading people's technology, their personal technology, which was much more primitive 25 years ago than it is now. And the technology companies, notably Google and Facebook and Microsoft and Apple and others, developed their own encryption in order to protect their customers from the government's intrusion into their technological devices. So encryption is advanced so rapidly that it's now at the stage, and it's a bit different for Apple products than it is for Android products. I'll explain that in a moment. But encryption's advanced so much that the companies are able to develop encryption that cannot ever be broken. And the way that happens is that encryption happens in streams and bits. So if you go to a certain power, a number of bits at the 32nd power, when you leap to the 42nd power, it means that the string is so long that it would take years and years and years with the fastest computers that exist to actually break that encryption. So it's only a question of how much more intense the encryption gets before, practically speaking, it's not possible to break the encryption. Even if you develop a program to actually do the job, it will take so long based on the power of existing computers that it's effectively ineffective and won't be able to break it. And all of this has come about because the government has wanted to intrude, and you all know about the Edward Snowden case, you know about the billions of documents that the government was capturing and pieces of information without the authority to do so. I mean, that case is an ACLU case. We've won it on all rounds in the court system. Clearly, the NSA was overreaching. Again, it's just about having probable cause and getting a warrant. We don't want terrorism to exist in this country. We don't want the government to be unable to do its job. We want to make sure that, those who have bad intent against this country are captured and prevented from doing any bad acts against anyone in the United States or against this country. We just want it to be done legally and constitutionally. That's really the only important point to make here, is that we want to help the police and the government do their work, but we want to make sure that they're following the rules. And the rules are in the Constitution. You've got a certain number of amendments, 27 amendments. They came about over many, many years, but the first 10 came about within 3 years of the passage of the Constitution, and they are rights that have been important opportunities to protect every person who resides or visits this country, resides in or visits. You don't have to be a citizen to have your rights protected. In America, you could be a visitor from anywhere in the world, and if some action happens against you, the Constitution is designed to protect everyone within the borders of this country. And that's a very important distinction, because people get often very hung up on the idea that it's only American citizens. No, there are lots of people who are here legally, who are working here, people who have applied for citizenship. It takes 5 to 20 years to become a citizen in this country, depending on what category you fall into. People travel here. We want to encourage tourism, people to spend money in this country. You want people to come here and know that their rights are protected and they're not going to be violated because they don't happen to be an American citizen. So it's very important conceptually to understand that this Constitution was incredibly far-reaching at the time that it was created. No document like this had ever been created before, with all of its flaws, all the things that obviously needed to be amended and changed over the years, whether it's dealing with people of color and starting as 3/5 of a person and being enslaved, and then having to go through the amendments that addressed equal protection and due process. We had a lot to change, and we still have a lot more to improve in this country, but let's do it constitutionally, let's do it legally, let's make sure that we get these things done as quickly as we can, but let's make sure we don't trample on people's rights at the same time that we're trying to make sure that we protect everyone in this country. And as you listen to this presidential, these debates on, I'm going to say ACLU is a nonpartisan organization. We don't get involved in supporting candidates. We don't get involved in supporting political parties. What we do get involved is making issue commitments and statements. And I think it is fairly safe to say that there are a lot of people running for president who are making some fairly egregious statements that are completely violative of our constitutional freedoms and protections, and who have distorted the facts and the truth numerous times, many of the candidates. And I think you can all figure out for yourselves which candidates we might be talking about. But I think it's really an extraordinary time in this country when, to be really quite serious for a moment, when we're watching people publicly make statements running for the highest office in this country that are so easily dismissive of entire groups and religions and categories of people's ability to exist and function in a democratic society. It's really a time like none that I remember, in my 60 plus years on this planet. I don't ever remember a presidential election quite like this, and with the kinds of statements that are being made that so many millions of people seem to be either not caring about or responding to as if somehow they don't carry weight or don't matter. That just because they're angry or upset, it's okay to say anything, and it doesn't matter what the implications of that are. Well, we obviously believe very differently at the ACLU, and we think words do matter and they have great meaning, and we do think that when you try to trample on people's constitutional rights, we've got to be the ones who are standing up and defending your rights. Now, one of the important rights that, and you probably all are quite aware of the fact that in the First Amendment there are rights that are in tension with one another. So you have a right, for a free press. You have a right to the government not mandating a religion and to freely express yourself with whatever religious beliefs or non-beliefs you want. You have a right to speak freely. You have a right to assemble freely, which means protesting. A right to redress your grievances with the government. Those are the 5 rights in the First Amendment. Sometimes those rights appear to be in great conflict with one another. For example, the case that I mentioned a little while ago, the Obergefell versus Hodges case at the Supreme Court that mandated equality for same-sex couples to be able to get married and enjoy all the rights and responsibilities in every state and federally. There's now a whole raft of bills being introduced in many state legislatures, not in Connecticut, but in many others, that are religious freedom laws, loosely categorized, that are attempting to actually recodify discrimination in employment, housing, service, and public accommodations against LGBT people. It's obviously not only wrong-headed, but it's unconstitutional. We're fighting those bills in every state where they're popping up. And we're winning in most cases, although some of them are going to have to advance through the entire court system. It'll be interesting to see which ones get to the U.S. Supreme Court in a particularly interesting time when we only have 8 justices and a Senate that doesn't seem yet willing to even consider a nomination by the president, so that there's nothing to tell us when we might have a full complement of 9 justices on the Supreme Court. But in this interesting time, we still have to deal with these issues and these cases, and many of them are really critical to fundamental rights for people in this country. There's an extremely important reproductive freedom case coming out of the circuit that is Texas, Oklahoma, and Louisiana. That is a very bad decision at the appeals court level, and if the case doesn't get remanded by Kennedy back to the appeals court, a very bad decision will end up standing, and women will have literally virtually no opportunity to make a choice to even see a doctor or go to a clinic that could perform an abortion if that's their choice. So there are some really serious problems that we're having to address that are larger than just the basic rights that you read about in the Constitution. They're based on many Supreme Court decisions that have had great effect and weight over the years. And the Griswold decision that I referred to earlier is the one, as I said, which had the first introduction of a right to privacy that had ever been determined in a Supreme Court case that is fundamental to the Constitution. And that is fundamental to all these decisions that we're talking about. They all emanate from that incredibly important case that happened right here in Connecticut. I think what I'll do is stop here for a moment and just open it up to any questions and be able to have a conversation with all of you. But before I do, I just want to say, you would expect this, I'm sure, from me, but we're doing incredibly effective and important work here in Connecticut. We don't have a lot of staff. It's an 8-staff organization, but it's 8 brilliant people. And the only credit I take is for hiring the brilliant people, but they're doing extraordinary work in both the legislative and policy realm, in the legal realm, in the public outreach and education advocacy realm. So if any of you are interested in considering becoming a member, there is information on the piano, both our magazine and also membership forms. We would love to have your support, obviously. And there's a very important activity that's coming up on the 23rd of March, and there are these brochures on the piano as well. Our annual lobby day, which is taking place on March 23rd this year, so it's not very far away. And it's an opportunity for you to come to Hartford and be able to meet with your legislators, to hear some really important speakers talking about these bills, including some of the legislators who are the prime sponsors of the bills, to be able to ask your own questions, to be able to advocate for things that are important to you. We'll help you set up those lobbying appointments. But if you are interested in this, you could take one of these. You could just sign up right on our website, and we're delighted to have you come and attend and participate. So with that, I'm going to open it up to any questions. Thank you. Yes.
I'm concerned about the erosion of our privacy rights by both government and also the corporate sector, which already can go through our phones, our address books, read our note, and then we've got the coming Internet of Things, where all appliances in a home have antennas that are being embedded now by the manufacturers, are going to be basically spying on us and on our lifestyles and maybe for marketing purposes. But there's just, and then we've got the smart grid and the smart meters that are also doing the same thing. And a former head of the CIA, James Woolsey, who said, that it's a stupid grid for not just privacy, but security, national security as well. So I'm just curious, in terms of weighting the risks here of our erosion of our privacy, the government side versus the corporate side. I see the corporate side as way worse than worrying about a drone that might be studying, people to explore some crime. We can't really talk about one without talking about the corporate spying too, and the culture of just giving up our freedoms by ignorance. By accepting the Siri on your iPhone, that if you read the small print, it gives them the right to study everything about you, everything you do. Skype, I just reactivated that. You can, they can follow my stock trades and things that stock quotes that I get. And what right do they have, do these corporations and governments have to our personal information?
Well, obviously, there are some people who do it, rarely, but you can go off the grid if you want to. You do have that choice. With government, I would say one thing that's important to recognize as a major difference is that the government has the right to imprison you. The government has the right to take you through court and bankrupt you with legal fees and put you in jail. Corporations don't have that right, and so I think it's important to recognize where we do have opt-out opportunities. Yes, I completely agree with you that the corporate sector has gotten so invasive and intrusive, and we've allowed that to happen. But you do have opportunities, for example, the stores that are now advertising the face recognition software. Every time you walk in to Macy's, your face is recorded, and they then send you advertisements based on your credit card purchases that are geared towards the things that you've purchased. Well, you can opt out of that. You could choose, first of all, not to shop at a particular store if you want to, but secondly, you can also contact the store and opt out. You can't do that with the government. That's one of the things we need laws for, is to protect us from government intrusion. And the Constitution, if you think about it, is a compact between the people and the government. It's not a compact between private business and people. Those are individual contractual arrangements that you can or cannot make, and they get more and more complicated to get out of. I completely agree with your sense of how invasive this has become. But the difference is that that compact that we make is based upon a set of protections, constitutional rules and protections that define the relationship between the federal government and then in each state. Here in Connecticut, the Connecticut Constitution, which was in fact the first constitution in the United States, and it allows for us to have a mechanism through the judicial system to be able to redress what we consider to be intrusions or grievances, and to be able to attack those through advocating for legal changes through legislation, through going to court and litigating these cases, through public advocacy and the fact that you have the right to free speech and you can protest what the government is doing. That's quite a different situation than being in a relationship that is really upsetting with a corporate entity. We do need to address, for example, corporate drones can do a lot of things that we may or may not like. I mean, they may think that in being able to deliver a package to your front door with a drone that they're offering you a service, but you have to make a decision as to whether or not you think that is actually giving them too much access into your private life and information, the way you discussed on Skype. It's true that, very, very few of us ever read every word of those agreements for every app on our phone that, are 28 paragraphs long, and we all just hit accept, right? I mean, that's what we do. Well, there are actually some good legal precedents, cases that have been won that hold the companies accountable for the fact that it is unreasonable to expect that every individual, not knowing what their level of reading ability is, their level of comprehension might be, that they can actually read that and understand the legalese that's in those agreements. So if you're willing to go through the expense and the time and emotional aggravation, you do have the opportunity, at least constitutionally, to take those entities to court. I mean, some people do it, and that's how we end up with these legal precedents. And it is a lot of work, and it's a production to do it, but it is quite different, your relationship between a corporate entity of any size, whether it's as big as Apple or it's as small as your corner store, and how you relate to it, whether it's in person or online. I mean, lots of people still choose to pay their bills by writing checks and not to do it online, and your exposure is much smaller when you are sending in a paper check than it is online, although your exposure is still highly expanded from 50 years ago, certainly. But we live in an age of technological advancement, and that was my point earlier when I said that the laws have clearly not kept up with the amount of aggressive technological improvements that there have been, and we get a lot from them that's positive, but we also give away a lot of our privacy and our personal information every time we engage online. And I think everybody's quite aware of the fact that all the ads that come along with every single site in which you engage are more and more geared towards, it's not a coincidence that the personal dresses that you like, or the personal furniture that you like, or the personal china that you like, or beauty products pop up as ads next to almost everything you open up, because it's a system now that continues to refine its choices so that it builds on every single purchase that you make and every single website that you look at, and they then provide you the opportunity to see things they think you are going to want. But you have the right to disengage, and you can unsubscribe, and you can take yourself out. You don't have that right with the government unless your right is protected through a law. I think that's the really big difference, and it might not be satisfying but it's actually really quite critical in the way we live our lives in this country if we want this to still be an America where we feel that we've got those constitutional protections.
You said the government can't read our mail, but they do track who we send something to and who we receive things from. Do they have the right to do that?
No, but I'm not sure that the statement is correct either. The government is not supposed to be tracking either by email or snail mail who you're receiving mail from or who you're sending it to.
I'm told they are.
So that is a new one for me, and it's something I promise you I will ask my legal director about, and we will, do at least a preliminary scan on that. But that is not something the government is supposed to have a right to do. Yes.
On the Stingray cell phone reader, is that something that only the police have, or can anybody buy one for $6,000?
Now it's open to anybody, actually, to buy one, although that is changing very rapidly. This technology and the access to it, in whether it's online or at, does Radio Shack even exist anymore? I don't think so, does it? Does it? I'm getting yeses over here. I haven't shopped in these stores now. I buy everything online too, like everybody else. So I think you do have access to some of these, and you certainly have access online to buying these. The fact that there's no legal restrictions on them means that, yes, you can invade someone's privacy, but there are also other laws in place. For example, different states, and there are some federal laws, but these are more state-oriented laws. You have more or less opportunity to do unmitigated spying through cameras or through recording conversations. It's different, literally, state by state. In Connecticut, the laws are actually pretty strict against your ability to capture information without permission. But the fact is that you can buy all of this equipment and you can do it surreptitiously, and yes, it's very invasive and very bothersome. The trial that just took place in which the sportscaster just won $55 million, we'll see what it turns out to be after it goes through the appeals process. But that's exactly the case you're describing. Somebody private and a hotel not giving them protections that obviously the jury thought should have been in place. And those cases can be adjudicated in court. It's an imperfect system, but it's very different than if the government is spying on you, because the government has so much power and so much money and resource compared to any individual citizen. Even if you're Bill Gates, the government's got way more resources than you do. So the difference in power dynamic, and also in the fact that the government, unless there's a law against them doing something, the assumption now has become, at the federal level and in many states, that if there's no prohibition against something, we can do it. And that's not the way this Constitution was written. It wasn't the way this democracy was formed, but that has been the default position that in the last, I'm going to guess, 30 or 40, 50 years has really come about, and technology has enhanced the ability of government to take that posture, because if there aren't laws protecting you, it's very difficult to find out what the government is doing. Freedom of information, we use FOIA requests constantly. We have a project going on in the Connecticut affiliate of the ACLU that has FOIA'd every single police department in the state with regard to military equipment they have, with regard to cases that have been adjudicated against individual police officers that have cost the taxpayers money, with regard to violations of people's civil rights, with regard to taser usage and recording of the data and deaths, with regard to gun deaths, a wide variety of things. These are taking up a lot of time, but are very important projects to be able to collect the data so that we're able to then file the appropriate lawsuits against the offending police departments and local municipalities for violating people's rights. But until you have the information, you don't know what is being done. The ACLU is the only one doing this. There is nobody else who does this work except the ACLU in protecting your constitutional freedoms. I'm personally really glad we're here, and I'm more glad now that I'm working for them than I was even when I was a board member because I understand at a more intense level how much violation there is and how critical it is for an organization to stand up to this and be able to hold government accountable for its behavior.
And so in regard to drones, let's say my neighbor buys a drone. I mean, I saw them recently, they're this big, and they're kind of cool. But I mean, if he's got his drone flying over my house, peeking in my window, what are my rights?
And those rights depend on the local jurisdiction, the state that you live in this country, and some are passing laws more rapidly than others. Again, that is different than the government having the right to spy on you. But the fact is that the young man who weaponized a drone, who's gotten a lot of publicity for several cases, he was originally sued by an internet altercation with a single mother on a beach who thought that his drone was spying on her teenage daughters in their bikinis lying on the beach. And that's how this entire thing blew up into literally a national and international news story. So, one of the good things we have in this country and that we're fighting very hard to protect is transparency, is openness, is access for the media both to investigate and for us to have access to the media. But one of the most important issues is open access to our courts. So as we're supporting a bill to raise the age of juveniles in the juvenile justice system, we're simultaneously, in the testimony we're going to be delivering on the 23rd of March at the hearing, and we've been in a lot of conversations with the governor, with Mike Lawler, who's in charge of the governor's legislative program on criminal justice, with many legislators individually, the chairs of all the committees. We've made it very clear to them that equally important from our perspective is that we maintain an open court system, that access to the courts must be open, because if courts are closed, nobody has any idea what's going on, what kind of personal biases judges are bringing to cases that are being decided. If they have a personal bias against people of color, a personal bias against, lesbians, a personal bias against women, it's very difficult to know unless you have an open court system. So we're constantly having to find that balance and advocate for all of those aspects of our First Amendment protections. I saw a hand. Okay, we'll go to this side of the room.
This is to address what you just re-mentioned about increasing the age for the juvenile system. The military age to join the military is what, 17, 18 years old?
18.
18. So do we assume that their brains are fully formed?
No, and I think...
With a rifle?
No, I think it's a very serious problem that you're raising, actually. And if you think about the ages at which people are allowed to engage in certain activities or behaviors, it's all over the map. You can't rent a car by yourself till you're 26. So, for a long time, people have recognized the judgment in operating this 3,000-pound vehicle and what damage can be done to human life is something that needs to have a different age than voting or than going to join the military. To driver's license at 16. Some states 15 and a half. Other states 18. It's all over the map. So I think your point is critical, which is we are finding out more and more information about the formation, scientifically, about the formation of people's brain centers and what they're capable of doing at different ages. We've made assumptions for many, many years. Connecticut was one of the last states, one of the 3 last states in the country to raise its age of juvenile justice from 16 to 18. That was only 6 years ago. The point is that we learn more, we are able to frame this understanding differently and make different and perhaps, we hope, better decisions. But there is no unified understanding of when people should be allowed to do things. And frankly, I'm going to be a little bit cynical here. Not that it will surprise anybody, because I'm not the first one to think this, but there's a reason why the government in virtually every country is able to conscript people at 18 into the military. Because they are more malleable. They are more easily controlled. Their judgment and behavior are less well developed, and they can form them into fighting machines that they need to just obey without questioning. It's much more challenging to do that with people who have a lot of life experience or coming in at 30 or 35 into the military. So that may sound a bit cynical, but I think, you're asking people to go and do really some frightening and horrific things potentially when they go into battle in wartime, and it's unconscionable, I think, but governments have been doing this in every country for many, many thousands of years, conscripting young people to go do the battles and fight. So that's a whole other lengthy conversation I'd be happy to get into with you, but I don't think that because the age of doing something is pegged at a particular chronological moment in someone's life means that that's actually relevant to when they're able to make the kinds of judgments that you then have to hold them accountable for. And so when young people are getting involved in drug activity, nonviolent drug activity, there's always the ability of prosecutors, even if you're 12 years old, if you commit a murder, you can be tried as an adult. Whether I agree with that or not is a different issue. But on all of these serious violent crimes, prosecutors always have the right to charge a juvenile as an adult. We're talking about non-violent crimes, which are mostly drug-related and otherwise mental illness related. That's 90% of all of those misdemeanors and low-level felonies that are non-violent are in those categories. That's what we're trying to preserve people's rights to not have their whole lives destroyed at 18, 19, 20 years old, when obviously there are better ways to educate, remediate, give them services, be able to get them back on a proper path, give them the kind of counseling and support they need so they can go to college, they can get a job, they can be productive, pay taxes, be part of the society. Every day that somebody's sitting in jail is $120 a day. It's cost the taxpayers a whole lot of money to keep people in jail. And it's why you find this bipartisan support for criminal justice that's now going on in the last 2 or 3 years all across the country. And people want it for different reasons. Conservatives want it to save money. Liberals and more progressive people want it because it's a social justice issue, and it's one which looks at a medical and therapeutic model rather than a punishment model, because there is really very little rehabilitation on a practical level that goes on in adult prisons in this country. We happen to be doing more in Connecticut now in the last 2 or 3 years to try and change that to a more rehabilitative model than most states in the country, but it's still not an adequate system for trying to reintegrate people back into society and reduce recidivism, which is at a very high rate, often over 70% in almost every prison system in the country. Yes?
So, I know this is a talk about privacy, but since you brought it up. So, we have a huge opioid problem, I guess, here in Southeast Connecticut, like most states.
I'm sorry, I'm having a little
We
hard.
have an opioid problem here in Southeast
Yes.
Connecticut, and we have a lot of people dying from pain and heroin. I see a guy get picked up in London the other day, arrested for selling drugs. There was no surprise. He's got 20 felonies to his name. So how is it beneficial to society to see this, quote, nonviolent offender released time and time again? And you're saying that...
Well, I'm not saying that that is a good thing at all. I'm saying that the current system is, unfortunately, these are systemic problems that one bill, or I'm not pretending one bill is going to solve the entire criminal justice system. So the point you're making is a completely valid point. I think that the issue is, if you get to somebody at a young age, you have a much higher rate of success and much lower rates of recidivism, of having people 20 times being rearrested for the same crimes. And you can look at the systems that exist in Germany, in Norway, in Italy, in France, in Sweden. There are a number of countries that have already put into place completely different criminal justice systems where there is not the punishment retribution model that exists in the United States, where they house prisoners in apartments that are nicely furnished, where they are able to watch TV, they have supervised access to the internet, they get counseling every day. The rate of recidivism in Norway is under 15%. It's over 73% on average in the United States. There are models. Germany is a very successful model also. There are models that do exist for many years now that are showing how a completely changed understanding of what's involved in corrective action for people who have violated the law are producing far better long-term results, and where people become contributing rather than taking from society. So we're stuck in this country often in many different issues with the overtones of people's own judgments, whether they come from their religious background or their educational background, the way they were raised, for some, whatever combination of reasons, we tend to bring a tremendous amount of judgment in this country to all of these behaviors we're describing. And instead of stepping back and looking more objectively and trying to figure out scientifically, what do the studies actually show us are the results? How do we improve the results, save money, and actually improve people's lives? We're just getting there now. We're starting to look at this in this country. Connecticut is very much at the leading edge of the curve in the whole country. And whatever you think about, Governor Malloy, some people are going to like things he does, other people are not, and you might like some things and not others. I could just share with you, because this is not about supporting a candidate. Governor Malloy is one of the most progressive governors on criminal justice reform in the United States. Whatever else you might want to think, it's the reason why Connecticut is moving forward. Now, we've had a legislature that's been able to be persuaded on both sides of the aisle, and the combination is allowing Connecticut to literally take the lead and provide a model for the whole country. Our second chance legislation last year was among only 2 bills in the entire country that passed to reduce felonization down to misdemeanors and take away nonviolent drug crimes from the 3 strikes and you're out, and release people in a thoughtful way with follow-up services so they're not just released and left alone and abandoned. This bill this year, if we pass it, I think we have a very good shot of passing it. We'll be the first one in the entire country. But we're not the first ones in the world. Many other countries have already done this and are showing excellent results. So, the United States is not always in the lead. We're the 26th lowest educational system. We're not the first in the world. And there are many other areas in which we're not number one. What we have in this country, and then I can see this is like the music at the Oscars, playing here.
The Grinch.
Right. What we have, I think we all know this here, is we have the best of each area, whether it's the best universities in the world, the best hospitals in the world. What we don't have is an elimination of the class system. We like to pretend that, Britain is such a class-oriented, or India is such a, caste-oriented system. We have class in this country, and wealthy people have access to education, have access to housing, have access to services and medical care. You can get the best of everything in this country, but everybody doesn't get, on average, the best that's available, and we're far down the line, as far as statistics across the world, in what we are willing to accept as the minimal base standard that everybody is entitled to receive. And that's a big issue that we're going to continue to struggle with here in this country, and it's one in which we're very involved at the ACLU, because a lot of these things are really fundamental protections. And we're doing a lot of cases of first impression and a lot of suits and litigation over the next couple of years that are going to be pushing the government on these issues here in Connecticut, because we can get certain things done here, and hopefully they will take off in the rest of the country as well.
I have a sense that
Thank you for your
Q&A session
questions.
could go on for some time. Steve has agreed. We'll be here there's a reception following this, and Steve,
I'll stay as long as anybody wants to talk. But thank you all. You're a wonderful
Thank you.
audience, and I appreciate being here. Come to Lobby Day, join the ACLU, make a donation. We'd be happy to accept it.